May I please? My lord, my opposite party has taken stay order by using a fact healthy. So I filed a vacation petition that may kindly be listed on Tuesday next. That is on 22.
You mention it before court number, whichever bench it is. I am bench. You have to mention before those bench.
I have seen it in your court.
No. Mention is before the senior bench. I'm the junior guy.
My lord, may I please, your lordship? Item number 2, that Cooperative Bank. My lord, the MS Chaudhary, the counsel for the petitioner, has informed me, my lord, that the file has been taken back by the client. Now no one has appeared.
He's appearing.
Wait, please, your lordship. Lordship, we are the newly engaged counsel for the Cooperative Bank, and will Mr. Sarankulla, our senior, will appear on behalf of the Cooperative. Lordship, may please speak the date before 23rd. And in the meantime, we'll file an affidavit.
What affidavit?
Regarding the.
I don't know.
Let the matter be read.
Yes, sir.
That matter. No case. The instant writ petition has been filed challenging the order dated 17/9/2015 passed by the subdivisional magistrate Hosai, directing the respondent number 4 to hand over the possession of the disputed land to the respondent number 5. From the materials on record, it reveals that there has been certain disputes between the petitioner as well as the respondent number 5. In respect to possession of a land measuring 2 bighas covered by Dag number 22 of annual patta number 38 under Moza Lamding. In view of such disputes, proceedings under section 144, 145 and 146, oblique 146 was initiated by the respondent number 5.
No,
by the petitioner, which was registered and numbered as, what is the number?
MR case number.
MR case number 209/1999. The said proceedings was disposed of by an order dated 3/12/2001.
22/8/2001. Page 100, madam. Oh no, it's signed 3/12 on the top of the at page 103 order is written 22/8, madam, but it is signed on 3/12. So it will be 3/12.
On 3/12/2001, by declaring the possession of the land in favor of the respondent number 5. The petitioner, being aggrieved, filed a revision petition number 199/02 before the Court of the Sessions Judge Nagaon, which was, however, dismissed by the judgment dated 31/3/2003. Thereupon, an application was filed under Section 482 of the Code of Criminal Procedure 1973 before this court. However, the said revision application was also dismissed by the order dated 5/1/2006. Thereupon, the petitioner filed a suit before the court of the learned Munsif at Hosai, which was registered and numbered as title suit number 5/2008. Full stop. This court had perused the plaint of the said suit, and from the said, it reveals that the said suit pertained to a declaration for setting aside the order dated
91,008.
19/1/2008. The said suit is pending. It has been stated at the bar that the said suit is presently pending. Be it as it may, it is also relevant to take note of that during the pendency of the said suit, in the said suit, injunction applications have been filed by the petitioner, which was, however, dismissed. For an appeal which was filed was also dismissed. The record further reveals that the respondent number 3 had directed the respondent number 4 by an order dated 25/3/2014 oblique 31/5/2014 to hand over the possession of the disputed land to the respondent number 5. Be that as it may, the petitioner filed an application that the said directions should be kept in abeyance in view of the pendency of the suit, being title suit number 5/2008. To the said application so filed by the petitioner, the respondent number 5 had filed an objection stating inter alia that there was no restraint on the respondent number 3 to evict the petitioner from the disputed land. And further, that the application dated 1/7/2014 filed by the petitioner was a false and a frivolous petition. And the order dated 1/7/2014, keeping in abeyance the earlier order dated 31/5/2014, was without jurisdiction and in violation to the orders passed by this court, for which of this. Accordingly, the respondent number 5 prayed that the possession of the disputed land be handed over to him. Thereupon, the respondent number 3 passed the order dated 17/9/2015, thereby directing the respondent number 4 to take necessary action to hand over the possession of the disputed land to the respondent number 5, as per the order dated 2/3/2010, passed in Mizze case number 4/2008 in title suit number 5/2008. Let us see that order.
My lord,
Where is that order?
of 79.
Hmm.
That is at page 64.
Page
64.
This order dated 17/9/2015 has been assailed in the instant proceedings. The record reveals that by an order dated 1/10/2015, notice was issued and making it returnable by 6 weeks, and further directed that the status quo be maintained in respect to the land in which the respondent number 5 had filed an affidavit in opposition. A respondent number 3 had filed an affidavit in opposition on 9/2/2016. In paragraph number 3 of the said affidavit in opposition, it was mentioned that the petitioner had filed title suit number 5/2008 and Mizze case number 4/2008, wherein the said miscellaneous application was dismissed by the learned Munsif Hosai, Shankardev Nagar, by order dated 2/3/2010. And subsequently, an appeal was moved by this court by the petitioner, which was also dismissed by the appellate court by an order dated 3/3/2013. It was also mentioned that MR case number 209/99 was disposed of, declaring possession in favor of the respondent number 5. And all proceedings initiated challenging the said order were dismissed by the sessions judge, by the sessions court, as well as this court. It was also mentioned that that the then learned SDM, Hojai Sankodev Naba, had passed an order dated 19/1/2008 with a direction to the officer in charge, Lamding PS, to hand over the possession of the land in question to the respondent number 5, measuring 1 bigha. This court also finds it relevant to take note of an affidavit take note of the affidavit in opposition filed by the respondent number 5. From the materials, from a perusal of the said affidavit of the respondent number 5, it reveals that the facts already narrated herein above have been also stated, and as such, for the sake of convenience, for the sake of brevity, this court is not repeating the same. The record also shows that affidavits in reply have also been filed shows that affidavit in reply have been filed by the petitioner against the affidavit in opposition filed by the respondent number 5. In the backdrop of the above, this court have heard the learned counsels for the parties and have perused the materials and report. Yes, what is your case?
If your lordship kindly peruse this paragraph 14 and 15 of my writ petition.
Hmm.
That is my. That having the learned executive magistrate, my lord, having declared possession, now there is no question of handing back his possession.
Why?
Because it could have been executed only within 2 months, my lord, under 145.
No.
The possession was declared in 1999, my lord. 2001, my lord.
Hmm.
The order is of 19/1/2008 for handing back possession. How can it be executed? Had it been a decree of the civil court, I could have understood, my lord. The decree of the civil court.
Is there a limitation?
Yes, my lord. Because there is no direction in the original order for handing over possession. Because possession is already declared in his favor.
There is no original direction?
No, there is no original.
Show me that.
That starts at page 100, my lord.
Oh,
Continuously, if you go, my lord, it is 100.
Hmm.
104 is the operative part. Second last paragraph. So, under all the above facts and circumstances, I say so and so Hojai, satisfied to declare the possession over the DL in favor of the second party until evict. So, as of 2001, my lord, he is in possession. So, in 2008,
page 104.
page 104.
So from the above, I see man satisfied to declare the possession over the DL in favor until evicted by the court.
So, if in 2001, he
So
is
there was no direction for
There is
handing
no
over.
direction.
On the materials on record, the issue which arises for consideration is as to whether the impugned order could have been passed by the respondent number 3.
3 months.
By the respondent number 3, thereby directing the respondent number 4 to hand over the possession to the petitioner, to the respondent number 5. When in the order dated 22/8/2001, there was no direction by the respondent number 3 to hand over the possession. The record, therefore, the materials on record already discussed herein above clearly shows that the petitioner had filed the said proceedings being MR case number 209/99. The said proceedings culminate with an order passed by the learned executive magistrate, thereby declaring the possession in favor of the respondent number 5 until evicted by due course of law. The tenor of the order, therefore, can be assumed that the respondent number 5 was in possession of the disputed land. However, the respondent number 5 have not filed any application thereafter for the purpose of handing over the possession, or for that matter, thereafter have not filed any application under the provisions of section 145 for application seeking initiation of proceedings under 145 to the effect that the petitioner had dispossessed the respondent number 5. It is also apparent from a perusal of section 145 of the CRPC that the said proceedings has to be initiated within a period of 2 months from the date of the alleged dispossession, isn't it?
Yes, ma'am.
What is the language used?
When an executive magistrate is satisfied from the report of a police officer or upon other information that a dispute likely to cause breach of peace exists concerning any land or water or the boundaries thereof within his local jurisdiction, he shall make an order in writing stating the grounds of his being satisfied so, and requiring the parties concerned to in such dispute to attend his court in person or by pleader on a specified date, and put in a written statement of the respective claims as respects the fact of actual possession. That is the initiation, madam.
Huh?
That is the initiation of proceeding,
That
madam.
I know.
Then
I'm theoretical.
4, my lord, subsection 4.
Hmm.
The magistrate shall then, without reference to the merits of or the claims of any of the parties to the right to possess the subject of dispute, peruse the statements so put in. Here the parties receive all evidence as may be produced, take necessary so and so, so and so, and the order made by him under in possession of the subject of the dispute. So he'll declare the possession, whoever is in possession. He'll decide whether any of the parties are.
No. Provided if
Provided
it
it
appears
is
to the mayor that any person has been forcefully and wrongfully disposed of within 2 months,
Before the date-
next, before the date on which the report or the information was
Exactly.
received by the magistrate or remand, before the date of his order under CI, he may treat the person so dispossessed as if that party has been in possession of it.
Exactly, and the
So
power,
therefore, it has to be 2 months.
the 2 months.
Have
And the
not filed
power-
an application. Right. Within a period of 2 months from the date the person alleging dispossession have been forcefully and wrongfully dispossessed. Full stop. Under such circumstances, it is therefore the opinion of this court that the respondent number 3 could not have directed the respondent number 4 to restore the possession of the petitioner, possession to the respondent number 5 on the basis of the order dated
312,
22/8/2001,
signed on 312. Page 104.
passed in MR case number 3209/99, which was signed on 3/12/2001. Consequently, the impugned order dated so and so is set aside and quashed. However, liberty is given to the respondent number 5, if so agreed, to proceed in accordance with law. And the observations made herein above shall not affect such proceedings if so initiated.
Only one thing, my lord, initially Lordship has said the dispute is with regard to 2 bighas, it is with respect to of 1 bigha.
Say one.
Item number 2 for motion.
Lordship, I have returned the brief to the
Yes,
wait.
fantastic. Tell me, how many people are there?
407, ma'am. I have the list, ma'am,
Of?
of shareholders having voting rights, ma'am.
No, how many shareholders are there?
407, this is the first list, my lord.
And how many persons were present?
In the last occasion, 97. First, in the first annual meeting, 67, subsequently 97.
Huh?
97. 97.
Hey, Cooperative Society Act. List of shareholders becomes one. And when was the meeting held?
Meeting was held 10 December 2023.
How will you bring in to 2022-23 the voting rights? The list has any relevance?
My lord, this is the press list. We have got.
You have, it was 2023-24, but it was 2022. As per the attendance register, out of 1571 numbers of A-class shareholders, only 74 members having voting rights were present. So are you saying that this particular proceedings which have been recorded is being done wrongly?
No, my lord, this
And
1571
Mr.
number.
Talukdar, how many, who are the people who can vote?
My lord, only 1571 numbers has been recorded wrongly. Only the numbers, that is 1571 numbers has been recorded wrongly.
In this,
My lord,
Proceedings.
Lordship will grant me 2 days time. I'll obtain written instruction detail. That will be more convenient. for me. If necessary, I'll put on record also. 2 days
Huh?
time may be given. 2 days time may be given.
no, just one thing.
My lord.
This is the, who are the persons who can vote? Yes, take this.
Sorry, my lord. It is in the. এখন না লাগে। It starts, my lord, from section 27.
Hmm.
Votes of members and manner of exercising vote.
Hmm.
In primary cooperative society, irrespective of the shares held in the society and subject to temporary disqualification, each member shall have equal voting rights. Similarly, in case of secondary cooperative society, the representative of such cooperative society shall have some voting rights. Every member of cooperative society or the representative referred in shall exercise his vote in person and in the manner specified in the bylaws, and no member or representative shall be permitted to vote by proxy. So each, my lord, the member who is a member, a shareholder, he have the voting right. Each one will have the voting right, unless there is some disqualification.
No, I think the bylaws
Bylaw.
normally say, I don't know, but they have not brought in the
Yes,
bylaws.
bylaw. There is a bylaw, man.
Yes, these bylaws normally say
Yes.
that to be a voting right, you have to pay your dues. Also.
No, that is, my lord, in the year also, my lord.
Normally, in
Yes.
all bylaws, I don't know here. Just for example, in our bar association,
my lord,
if you may be a member,
Right.
but to have a right to vote is only to those members who pay the subscription.
Yes, correct.
So there must be something, and in view of that, in a recent judgment of the Supreme Court,
Right.
I issue arose as to whether any other member who have not paid the dues
Yeah.
would have a right. The Supreme Court said no. If he does not make the payment, he cannot.
So,
But the quorum has to be on the basis of what? What is the mandate out there?
quorum, my lord, 34.
Of the shareholders present, or what is the
30,
is the-
34 says,
Uh.
34 says, members eligible to vote.
so
Members
these
eligible
were
to
the
vote.
people who were eligible to.
vote. Yes. So that figure, my lord, would be necessary.
And in fact, they have to put it by way of an affidavit.
Yes,
Who
correct.
were eligible.
Yes, yes, correct.
If you
That-
don't put it,
Then-
and then he has to cross check.
Yes, yes. That figure would be necessary.
Otherwise, you have no case.
Let the affidavit file for you.
No, we'll file an affidavit method, but certain these methods, there are other criteria that need to be fulfilled. Whether it is in terms of operation of the area and some other terms are also there, which will bring in the affidavit,
Into detail.
which will bring in the affidavit, my lord. There are other eligibility criteria, my lord,
Detail, detail.
that needs to be fulfilled. And after fulfilling those criteria, this list has been prepared, my lord. That we will bring in the affidavit, my lord.
That you have not brought it.
No, my lord, we will file the affidavit in the meanwhile. my lord. We have been newly engaged.
Because as of from a perusal of your minutes, it does not show. It shows categorically that 1571 are the members who can. Because this list also show how many, what the last of the membership number is 3474. With meaning thereby there are at least 3474 members.
Shareholders, members, correct.
So under such circumstances, you have now put it at 1571. Now, what is this basis of having now these lists less than that 407?
My lord, the other,
When which is contrary to what is written out there in your minutes.
my lord, it does not qualify the other criteria, my lord, because some have expired and some did not attend meeting for three general meeting, my lord. So these are some criteria, my lord. So these we will bring in the affidavit, my lord. There are some other criteria,
How much time?
my lord, preferably on 23rd, my lord, February. In the meanwhile, we will file affidavit, my lord.
At the request of the petitioner, matter stands adjourned to be listed on. Why 23rd? What is so lucky about that day?
No, my
on
lord, any
Tuesday.
date, my lord, any date, because 1 week time may be given, that is.
Be listed on 29. 29/1/2020.
29-2, man.
29. Oh no, I'm sorry. 23rd, I'm taking. 23rd is right. So 23rd.
20.
Means again, I was looking into January.
My lord. Obliged, man.
In the Mr. Taluga, in the meantime, you find out.
My lord.
Take this list.
I'll try to find it. এখন এটা কপি এটা মোক দি দিব Obliged.
Wait, your lord. So in this matter, Mr. H. Buraguhai has received some instruction, my lord. He is on legs in court number 1. Matter may be taken after submission. He will be coming.
My lord, I have filed an rejoinder, my lord. Yesterday, the requisition is not in records, my lord. So, and I cannot prepare this case because some food poisoning is just yesterday, but still, it's a affidavit I have filed, my lord. One rejoinder, bringing that plot of land 205, my lord, when acquisition is made, it was kept outside the purview of the land acquisition. That is why the petitioner of item number 5, he has got mutation and he paid the revenue. In circle officer report also said that he purchased the land, whatever maybe 99 or settlement or purchased the land, he is paying the revenue. But problem started in 2009, my lord, when this petitioner submitted an application for permanent settlement that was ignored, and after 2011 he found his name is deleted from the records. He want to know how my name is deleted from the records. And secondly, my lord, they said that 202 is their land, my lord. That is absolutely how they can come 205. That inquiry was made in earlier before circle officer proceeding, but they have not come with the sale deed or mutation order, because once they get settlement on 202, that is correct.
Your mutation has been done.
Well, my only thing is this, Manoj, he is the interloper. He has nothing to over there. In a rejoinder which he has filed yesterday, I found that there, because I am in possession, I have started construction. This is only because of all this he is tracking that creating and
No, no,
Manoj, because that he in his yesterday's affidavit also he stated that the construction I have started taking permission and everything, because now, Manoj, there is some dispute he is creating.
Now, what right you have over the land?
Manoj, in his affidavit, he has said,
My lord,
Let me
my lord,
hear. I have time now. I
my
have
lord,
only
my lord,
6 matters.
matter is simple to what I understood. That is
Simple.
yes, what I understood, my lord.
No matter simple.
Yes, 202 is their land, my lord. I have not disputed that.
No. Forget about other things. So you're right.
Yes,
What is your right?
my lord.
Do you have a patta?
My lord, I applied for patta, my lord.
You have a patta?
As on today, no patta.
You have a settlement?
Yes, my lord, this
You
mutation.
have a settlement? Simple questions are these. You
My,
have a settlement?
my name was mutated.
As
My lord, kindly see.
as
As purchase or khado means as in mutation case number so and so. I have given it as possessor.
possessor.
Yes, and then I paid revenue also.
Okay.
Then
No,
resettlement operation.
wait. As possessor. What did you purchase? The
My-
rights did you purchase or the possessory rights
My lord, for 99-year lease
from?
from the Doloi, who has given some land to look after himself. So when the land acquisitions taken place, that was kept outside the purview, and he has this
And when was the land acquisition process initiated?
63, my lord, with effect from 10-1.
Huh?
10-1, 63.
Let us see the charitable institution. You can go.
My case is that that land was
No,
not
your
acquired.
case we will go into.
Yes,
First, let us find who are you.
My lord.
Charitable institutions act. Let
My
us
lord.
see. Acquisition of land belonging to 7. You see, notice of acquisition. The state government may from time to time by notification in the official gazette declare that all rights in land belonging to a religious or charitable institution of public nature shall vest in the state free from all encumbrances. With effect from the first day of the agricultural year next following the date of publication of such notification. Meaning thereby, if it is in the year 1966 anytime done, it will start from 1st of April, 15th of April, agricultural year will be,
That will be 15 April, yes.
means first day of Bohag. It will be on 15th of April, 1967.
Yeah.
Okay? Now let us. When was the notification issued under section 3?
Section 3. Notification acquisition.
Notification dated 5/4/1967, page 14 in my writ petition in the
5/4,
67,
page,
page 14 in WPC 5449 of 2019.
page 14.
Last paragraph. Thereafter, the land in question measuring along with land belonging to religious public purpose as per government notification dated present.
Where? Page?
Page 14, 14 Annex A.
So it will be effective from 15th of April. Because the Bohag will be on 15 or 16, whichever may be. So although it was issued on 5/4/1967, it will be applicable from 15/4/1967. Now, what right has been created upon it?
In 1966, I have purchased or I have taken lease.
Huh?
Prior to that, my
Wait.
rejoinder, my lord.
No, rejoinder will
I
look
have
into.
taken this
In
in
your writ
1962.
petition, I could see some document. Yes, where is it? In your writ petition?
My lord, in rejoinder, I have come with a my lord clear and translated copy, my lord. Kindly see it, deed, my lord.
Yes, give it to me.
Yes, my lord. Page
Deed of settlement.
67, my lord.
Running page
Annexure O.
67.
I don't have that rejoinder with me. So
Running
please
page
give me a copy of it.
Rejoinder is with
No matter in their affidavit is there. Running page 67.
In there?
Affidavit earlier to this region.
In which proceeding?
Well, this is in 7184 2021.
item number 5.
Yes,
Page
they have filed an
67.
affidavit.
Affidavit page
Rejoin number.
67.
Because
Running
my-
page,
67.
This is a
This is
registered
deed of
document.
settlement.
deed of settlement.
Yes, registered document.
These deed of settlement has been made when?
66, 16 feet,
66, my lord.
Huh?
Prior to
66.
Seed of 1966.
And my position is from 62.
my
Yeah.
lord, I have
No,
not
it's okay. Please.
This is not civil dispute, my lord.
This
They have
is
to-
being done by first party on behalf of Bokhisto Temple,
Yes,
Sanatan Sharma Duloi in favor area where the Patta land described in the schedule of the sale deed belongs to the Bokhisto Temple. The first party is the Duloi of the state temple, and thereby he has the authority and power to look after and protect as well as settlement of land belonging to the temple. Desires to get Miyati Patta of the land described in the schedule below and accordingly requested here for the same. Agree, and accordingly the first party has received a sum of rupees 900 from the second party for the benefit of the temple and had executed the deed of settlement for Miyadi Patta. The tenure of this Patta is 99 years with effect from Imam, and the second party and his legal heir are entitled to enjoy possession. Has to pay the revenue of rupees 35, which is the revenue and will be paid to the first party. Has the power to sell, give, or any other possession within the tenure of the. But in that occasion, the second party shall have to serve 1 month notice to the first. So this land was sold. It was a sale deed.
66.
This is deed of settlement. Ma'am.
Registered deed, my lord, and the possession, some portion is in, there is a riot, and this is relinquished after receiving the consideration. Page 69, my lord, one Balaram Bora.
And how big was dark number 205?
My lord.
How big was you were sold 205?
Yes.
He was sold 202.
Two.
My
Yes,
lord,
that is correct. And
You
this
were
is
sold
for-
what?
my lord, your lordship will find 202 at page 14 in WPC 5449 of 2019. 5449 of 2019, Annex A, page 14.
Who sold you?
My lord, yeah, Shamshuddha Garotia such and such, deed number, registered deed number 67/1962 after 99-year lease from Bosishto Devalaya in respect of such and such, covered by dag number new and such new such and such, payment of rupees 5,500 as consideration on the same day, that is 6/7/62, Shamshuddha
So
Garotia.
you were given 202 and 529. He was given 205.
My lord, there was
Correct.
205, 205 belongs to some other person, not
I'm not on that.
My lord.
You were only given 202 and 529.
529. My lord.
Now, what is their report?
The report says that he doesn't have any right.
No, forget about him. You say first yourself. What
My
does
lord,
the report say?
says if,
How does 2335 come in from?
it is further stated that 2335 has been partitioned in the name of, it was partitioned in the name of
No, from 202.
20.
Yes.
So
As regards the
2335 comes from 202.
20.
So his land is
20.
2335 comes from there.
There.
So yours is 205. And what has 205 now become?
That is, I want to know, my lord. They have not supplied any information regarding that and how my name is deleted. That is why I.
So your deleted now. So the question now will be as to whether 205. So you have no problem with his land.
Yes.
So 2335 is his land. So don't disturb his possession.
Yes.
So the question of initiation of any demarcation proceedings in 2335, the notice which he has challenged does not arise.
Correct.
Okay. You are agreeable to this?
Yes. I only concerned
Okay. We'll look.
205.
So let us first finish his case.
My lord, and my lord,
No, your case I'm looking at.
yes. Well, I have filed an. I have filed a rejoinder yesterday, my lord. My lawyer.
Understood. Your case is 205.
Yes, ma'am.
Absolutely 205.
And
Now we have to know what is the resettlement DAG of 205.
yes, my lord. I want to know.
And you have no other problem.
Yes. If my name is deleted, I want to know the reason.
You are asking that.
Yes, I always in 2012.
No, but one document out here,
Yes.
more particularly the one document at page 74
Yes.
of your affidavit
Yes.
of your restitution, 7184,
Yes.
clearly shows that this land was running in the name of Nepal Chandra De,
Yes.
who became the owner by way of purchase
Hi.
by mutation order passed by this court on so and so.
Yes.
Okay.
Yes.
So this is 205.
Yes, ma'am.
And during these two here, you see 205 as such became 2335, 2337, 2338, 2341, 2342, 2345, 2346, 2350, 2350. Well, so his is 2335.
Yes.
So don't disturb him.
Yes. It must come from 202, not 205. That is my question.
It is clear. 202 is 2335.
Yes.
Yes, sir.
Gone.
Yours is 205.
Yes.
From there, his length have come.
That is my.
Who is Shyam Sundar Garodia?
My predecessor,
Here.
they are my predecessor.
So you have no right of 205.
205, I'm not taking.
So we close it there. So you have no right of 205 or any of the darks which were carved out of 205,
Yes. I'm
meaning
not-
by 2337, 2338, 2341, 2342, 2345, 2346, 2350, and 2351.
No.
You have no business.
No, I am
Yours-
202 and 2335.
And why these claims being made by Rohit Prasad Agarwal and Shyam Sundar Agarwal were asked to bring the sale deed mutation order in respect of the land possessed by them, which was covered by dark number 205.
20. Well, that was the notice that they have issued to us.
So.
However, in reply, it was stated that a plot of land 2 biga 2 katha 1 lecture covered by 2658 Pata number Iman has been mutated in the name of Shyam Sundar Garodia 2658 and the land measuring 1 biga 2 katha Iman of dark number 26657 Pata number has been mutated in the name of Iman after partition of 4 bigas of the land between them. From so and so for collection of the it is covered by and the state asked that in the relevant covered by 205. Are you appearing for this Shyam Sundar Agarwal and Rohit Prasad Agarwal?
Here, the predecessors, my lord, they are Ashok Garodia, Santosh Garodia, and Dilip Garodia. They are the son of Shyam Sundar Garodia.
So you have no right over 205.
Well, I'm not telling anything of it.
So you leave them up.
Yes, but the LR staff says that they have possession, so their sale deed or any mutation order is asked from them. That is not
Right.
given.
Or
Now, if process is again just remanded back to them, it will be clear.
No,
And then-
why should we take into consideration your case for that? Because your is 205, they are 202.
Yes.
202 became 2335. And that is only 2335 remaining with them.
Well,
Yours is 205. And from there, 6-7 dark have passed.
Yes.
So if you have a right out there,
Yes.
why the name of the petitioner has been removed?
at page 18, my lord, the notice says for 205, I have been given a notice. Page 14 in my page 18 in my repeating. For dark number 205, I have been asked to proceed and submit everything. Page 18 in my petition. I replied to everything. Again, thereafter, another notice came in.
So what are you asking in your relief is a declaration that this
Declaration.
court should make
Yeah.
in your favor that you are the owner.
Owner,
205. I'm not
No,
claiming.
understood.
My lord, kindly see
And
this.
then for a demarcation of dark number 205.
Yeah. Yes.
Now, it is the admitted stand of the respondents that 205 is 2335.
Yeah. My lord,
202.
203.
And 205 are these 5 dark.
Yes.
So why the respondents out here have asked for demarcation of their land of 2335?
My lord, in my petition, kindly see page 46. This is the report. That is why they are serving.
Hmm?
Annexure I, page 46 of item number 5. Kindly. This is the report.
You are challenging which document, Mr.
My lord, at page 18 and thereafter at page
Page 17?
17.
Why 18?
My lord,
Why 18?
18, my lord, because notice was sent to Shyam Sundar and Rohit.
So?
As regards 205.
So?
20
So how are you bothered? Don't go.
that is why, my lord, I replied. Then thereafter, they have again asked for my document at page, your lordship will find at page 30. Page 30, they have again asked me to page 30 as regards 2335.
Where?
Page 30 and the translated copy at page 29.
revealed that you have been holding land into the, hence you are asked to appear before the court of the undersigned along with the document. So, what is wrong?
But I have submitted everything.
So go there. Why are you challenging this document?
Because, my lord, at court, previously, my.
No, are you rendering this court to a what court? ADC?
No, not the executive court. Or
No,
neither
ADC.
No,
Or do I look like a circle officer?
my lord.
No,
Your
tell
lordship
me.
looks like a
Huh.
lord, man.
No.
Nothing.
Then why are you doing all these things before
Lord,
this court?
because he is harassing me through the revenue authority.
So go there.
I'm sworn
Write
and
it out
we-
there.
We have filed all our applications.
No, then
My lord, those applications are pending. They are not doing anything, man. We have submitted all our
no,
replies.
you have got today the mutation of 2335.
My lord.
Be happy with that.
Right.
And go and file all your documents there. And here he wants a demarcation of 205. Do it. And from 205, these drugs are there, which is given out there in that this particular level. All of you go and fight your litigations before the circle officer or whoever it is.
Only thing, my lord, he has asked for a title also to a retreat. He has asked for title of the land of 205. His prayer is there
Who are you to say not to give? You are nobody to 205.
because
It is between me and him.
I've been made a party to them.
Oh, it's okay.
My lord, why this problem arises because
Anyways, wait.
yes,
Let me okay, enough. Mr. Borua is famous for making things complete. Let us not make things complete. Both the repetitions are taken up for disposal by this common order, taking into account that the facts and the allegation are interrelated. From the record, it reveals, from the records as well as the admitted case of the petitioner in WPC number 5449/2019, it reveals that the predecessor in interest of the petitioner had purchased by the registered deed number 4045 dated 6/7/1962 a plot of land measuring 4 bighas 3 katha 12 lechas covered by Dag number 25 old oblique 202 new included in 41 old the oblique 521 new of the NK Patta number 2 Khatian number 17. The record further reveals that these lands, the record further reveals that proceedings were initiated by issuance of a notification under the provisions of the Assam State Acquisition and of Land Belonging to Religious and Charitable Institutions of Public Nature 1959 by the government notification number RRT.17/66/62 dated 5/4/1967. The resultant effect of the said notification and reading the same in terms with Section 3 of the said Act of 1959 and the definition of the agricultural year as defined in Section 2A of the said Act would show that the said notification had come into effect with effect from 15/4/1967. Thereupon, this land covered by dark number 25 old 202 new was settled with the predecessor in interest of the petitioners in WPC number 5449/2019. It is also seen from the records that this dark number 202 old during the resettlement operation, the 202 old, the dark number 25 old oblique 202 new covered by patta number 41 old 529 new of NK patta number 2. During the recently concluded resettlement operation, became
So lordship permit me to say one thing.
two 335 of patta number 1400 of village Dwaranda. Pustak. It also appears from the instructions kept on record and marked with the letter X that this very dark number 2335 was again partitioned amongst the legal heirs of amongst the successor in interest.
Here there is a big because my lord, first 1, 2, 3 are the predecessor of Shamsundar Agrawal, and Rohit Prasad Agrawal is himself he has got it that.
Let's do that.
That Shamsundar Agrawal 1, 2, 3 are the petitioners.
देखो,
Predecessor,
I have not come to the petitioner till now. देखो, ये लिख ले, खुद ही. Against partition amongst the petitioners in WPC number 5449/2019, and thereby the petitioner number 1, 2, and 3 was issued a patta, was issued a fresh patta bearing patta number 1675, and the new dark became 62658. However, as regards the petitioner number 4, petition number 4 is Rohit. His patta became, he was issued a fresh patta, being patta number 1674, and the new dark became 2657 new. It is also an admitted case where, in the backdrop of the above facts, if this court now takes up the case of the petitioner in WPC number 7184/2021. It revealed that a plot of land measuring 4 bighas covered by dag number 205 of patta number 2 of village Dwaranda under Moza Beltola was purchased by one Nepal Chandra De, bracket, since deceased, the father of the petitioner.
Yes.
By the registered sale deed, by the registered deed number 4527, dated 23/6/1966, and there was a mutation order dated 22/7/1967, passed by the office of the Deputy Commissioner, Kamrup Metro. This tag number 205 was subsequently, it is not known as regards the exact quantity of the land in dag number 205. However, it is seen from the records that this very dag number 205 during the resettlement operation became dag number 2337, 2338, 2341, 2342, 2345, 2346, 2350, and 2351. And patta number? No idea.
2, my lord. Niskras 2, 1 and patta number
And the
2.
patta remains the same.
Same.
Of the same patta number. It couldn't have been. Anyway, Nalagin became so and so. Therefore, the petitioner's claim, it is the further case of the petitioner in WPC number 7184/2021 that the name of the petitioner's father was mysteriously removed from the record of rights. And under such circumstances, applications were filed before the respondent authorities. Be that as it may, it is the specific case of the petitioner in WPC number 7184/2021 that the said petitioner's right is confined to dag number 205 old and the other and such dags which were carved out from the said dag, and not in respect of dag number 202 old, which subsequently was made dag number 2335 and presently dag numbers 2657 and 2658. In the above perspective, this court finds it relevant to take note of the challenge so made in WPC number 54459/2019, wherein the petitioner have assailed the notice dated 13/7/2018 issued by the Circle Officer, Dispur Revenue Circle. From a perusal of the said notice, it reveals that the father of the petitioner, that in view of an application submitted by the father of the petitioner, late Nepal Chandra De, seeking demarcation of the land, the respondent authorities have asked the petitioner to appear before the court and explain, appear before the court, before the circle officer, and along with necessary documents. In the opinion of this court, there is no, in the opinion of this court, that merely by asking the petitioner to produce certain documents by an authority do not require any interference under such circumstances. It is the opinion of this court that the question of setting aside the ordered communication, the notice dated 13/7/2018, does not arise. The petitioners in WPC number 5449/2019 would be well advised to place the relevant documents before the circle officer, Dispur Revenue Circle, and thereupon it is, however, observed that to place the necessary documents, appear before the circle officer, Dispur Revenue Circle, and place necessary documents in support of their claims. Now coming to the writ petition in WPC number 7184/2021. It is seen that the reliefs which have been sought for is that this court should declare that the petitioner is the owner of dark number 205 old in Nis Firaz Patta number 1/2 new in village Dwarnanda under Beltola Moja. And that the respondent number 528 are the owners of a plot of land covered by dark number, plot of land measuring 4 bighas 3 katha 12 lecha, covered by dark number 202 old in Patta number 1/2 new in village Dwaranda Moja Beltola in the district of Kamrup. This court is shocked and astonished at the relief which has been sought for, inasmuch as if the petitioner seeks a relief of declaration, the same has to be done before the civil court. As regards the other two reliefs which have been sought for in the writ petition, it is seen that the respondent authorities are already taking up such action and in consequence thereof have issued the notice dated 13/7/2018, which have been put to challenge in WPC number 5449/2019. Under such circumstances, it is the opinion of this court that as the matter is pending before the circle officer revenue circle, Dispur Revenue Circle, the petitioner would be well advised to take appropriate steps before the said authority. I've also heard Mr. H. Sharma, the learned counsel, state counsel, who submits that the circle officer, dispute revenue circle, is taking steps in pursuance to the applications which have been filed and bring the said proceedings to a logical conclusion after hearing both the parties. Taking into account the above, this court therefore disposes of the instant writ petition without interfering with the notice dated 13/7 with the following observations and directions. Number one, the impugned notice dated 13/7/2018. The notice dated 13/7/2018 impugned in WPC number 5449/2019 is not interfered with, and the petitioners would be well advised to approach the circle officer dispute revenue circle by placing the necessary documents as sought for. Number two, this court is not inclined to issue any declaration as sought for in WPC number 7184/2021. However, it is made observed that the rejection of the said prayer for issuance of declaration shall not preclude the petitioner in both the writ petition to approach the competent authority seeking declaration. As regards the other reliefs which have been sought for, that is for demarcation, as well as for correction of the records, the same is now being taken into consideration by the circle officer dispute revenue circle, and this court directs the circle officer dispute revenue circle to bring the said proceedings to a logical conclusion in accordance with law.
Within a time frame, Lordship, it's the time frame. Lordship,
Within a period of 4 months, 4 months from the
So
date a
again,
certified copy of the order is served upon the within the period of 4 months, 6 months, period of 6 months. Full stop. The registry is directed to serve a copy from today. The registry is directed to serve a copy of this order to Mr. H. Sharma for due compliance. This court would however like to observe that the land claimed by the petitioners in WPC number 5449/2019 arises out of DAG number 202. Whereas the land which has been claimed by the petitioner in WPC number 7184/2021 arises out of DAG number 205 old. This court in the preceding segments of the instant order have categorically mentioned the various DAGs which were carved out of the above mentioned two DAGs. The learned circle officer, the circle officer dispute revenue circle shall duly take note of while deciding that.
One IA is pending, to dispose of because there is stay order. That is why this file IA number 2982. Oblige. Huh? Oh, sorry. Huh?
instructor not call for into it. I have to think.
The grandfather of the petitioner was originally allotted. Grandfather petitioner, madam,
You don't.
was allotted. Now, the rules governing these villages, my lord, they do not confer any heritable right.
Who is the petitioner?
Petitioner is the successor of my few from Mahili. Originally, whom my land was allotted.
Then
Grandson. my pet.
after the death, you gave it to somebody else.
Yes.
Why?
No, these are not heritable rights, my lord. So there are some certain considerations.
Show me settlement.
This is the rule, my lord, governed.
Before that, your lordship may kindly peruse my page 23, my lord. The reply to the RTA application. Page 24 is relevant. Regarding question number 3, the answer is important. There is no provision for sale or purchase of forest. The forest cannot be sold or purchased. Page 20.
Not sale one. It's not sale one. Allotment is happening. This is a rule, my lord, which made under Assam forest regulation. These are this is a forest village, you know, rule 6, my lord. Next page.
When were these rules made? 1930.
My lord, these are of 1930. In 6, my lord, says no heritable right.
But did you comply with the earlier portion of section clause 6?
My lord, for that, my lord, it implies, my lord, they have to apply, my lord. They have to apply. They have to show that they have to apply.
Where is it?
My lord,
They
these
have to
reading,
apply?
my lord, the will be registered if he is considered, my lord. That implies, my lord.
No,
One
will
is
be
that-
registered as the forest
Villager,
villager.
if he is considered, my lord.
considered
Yes.
by the divisional.
To be
So,
suitable in respect.
Did you consider?
He has to apply, my lord.
Now, where is it mentioned that he has to apply?
Because, my lord, if you read, my lord, that portion and this, nothing in
Now,
this
is
rule
it
shall
your
be-
thing that he has not applied and as such you have given to somebody else?
Yes, my lord, because it's not heritable.
No. Where is it?
My lord?
Where is it in your order that you have stated to the effect that he has not
No, my lord,
applied?
if we
to it?
read 6, the front portion
Absolutely no.
and the bottom
Nothing
portion, my
doing.
lord.
This is not a thing by which you can do all this.
No, they have to, somebody has to apply it because no heritable right, because he is claiming heritable right. And the language, my lord, on the other hand, on the disease, my lord, if he's considered, if we read that with this, that, but nothing in
Let
shall
us
be
see
held,
the
my lords.
allotment order. Allotment made in favor of the petitioner. Father,
My lord, there is, as such, it is a very old, my lord, there is
One document, page 18.
118, my lord, there is only, my lord, this is receipt,
Money.
money receipt, my
Revenue
lord.
page.
being land revenue.
Yes.
And also, my lord, see, they are claiming 12 bighas, whereas, my lord, the rule says, my lord, you can only have 5 bighas.
When did the father die?
Grandfather,
Grandfather?
grandfather dies in, my lord,
Died
to
in-
2014.
Yes.
Huh?
2014,
2014
14.
died. And she applied when? She filed this declaration when? In 2014.
2014.
Yes.
Then?
My lord.
What else is required?
No, my lord, this act doesn't confer any, it cannot be done with, my lord.
What?
This, my lord, this, that she is declaring and passing on, my lord. If we see, my lord, that heritable right, my lord, they cannot inherit, they cannot give it on, my lord, to their successors. The language is plain and simple, my lord.
The
They cannot-
language is plain and simple.
Well,
Very well. On top of it, it's also
No, my
very
lord, that
simple.
is, if we read
Did
it,
the divisional forest, Mr. Gogoi, kindly don't digress from the point. Did the divisional forest officer take up this thing that they are not entitled to?
My lord, the language, if
The
he's
language,
considered by
we
the
cannot
DFO, my
read
lord.
only that the last portion in isolation or without the earlier
So
portion out there.
let them come and apply, my lord. We'll consider, my lord. We
What?
can consider, my lord. If that is the issue, my lord.
No,
can
we have to
consider.
set aside the earlier, the settlement which has been made. You can't give the settlement in this manner.
And that
When this
also, my lord,
application was there, this is,
yes,
are you
lord, yes,
saying
yes.
that the
In
forest dwellers have to know how they apply? Where's
my
your
lord.
application?
My lord,
Show
kindly-
me, where is it
kindly-
a
my lord,
requirement, there is an application to be
kindly
filed?
bear with me, my lord. One another aspect of this matter. They are claiming possessory right of a land. My lord, they might have rights under the schedule at that tribe act, but they don't have a specific, they cannot claim that I want this land only. If the government considers they are entitled for the right, they can be settled anywhere also.
No. On the deceased, the name of the Iman will be registered as a forest villager and if it is considered so and so. Now
Hello.
kindly see, an allotment of 5 bighas of
5
land
bighas,
to
and they are
include
claiming 12
homestead
bighas out here, my
or bari will be made
my lord.
for each resident household to which may be added 10 bighas. No, kindly see. On account of each working member
Member, my lord.
residing in that household, but no household should occupy more than 35 bighas.
My lord.
Thus, a household containing 3 workers, including the householder, would be entitled to 35 bighas. The land given out of the household will not be reduced in extent during the householder's occupancy if the member of the becomes subsequently reduced in the number. Non-resident villagers may similarly be allowed to cultivate up to a maximum of 30 bighas per household.
My lord, here 2 brothers have come. Assuming, my lord, only they are working. 10 bighas. So DFO is the competent
10?
authority, my lord.
What 12?
My lord,
Mother was there?
my lord.
There? Mother?
No, my lord, that, we'll see, my lord, one part has gone, my lord, the Saraswati Mahili, the other daughter of my lord, that, Shiv Sharan Mahili, she has separated and she has been allotted 1 bigha. That
And it
goes,
is high time you have to change these rules. These
uh,
are in complete violation of Article 14. Have you seen this?
my lord,
Can we take this thing as law now?
no, my lord.
Can we take this as law in view of
Well,
Article
basically,
13?
This was for the, my lord, when the forest was established, my lord.
Understood,
for-
but
for
if we
that
are
purpose,
going
this
by
was enacted.
this is in complete violation of
In that
Article
case, my
13.
lords,
Article,
this
the
can
fundamental
be
right.
listed on Tuesday, my lord. Perhaps I have an order, my lord. I have an order, my lord, wherein, my lord, the Justice Bhujavura, my lord, have dissected and given up on a very another interpretation of it. I can place that.
Definition means, how can you say as of now in 2024 of a rule made in 1930 that if the son remains, it will be named in the name of the son, but if the daughter is there, not in the name of the daughter,
No, we're not saying
but
daughter, my lord.
no, but in the name of
Oh,
the
male
husband
hire.
of the daughter.
No, my lord,
See?
in the case of married females, my lord, it is there. When they marry husbands suitable for employment as forest villagers.
Therefore, it will be only in the name of the
Purpose was
husband.
must be, my lord, these serve the purpose of forest.
Whatever may be.
It was in
You cannot say
1930.
that because as of now, can you say when you are having Article 15 and 16?
No, that is lordship is
Yeah.
correct. And that
These
My
rules
lord.
on the face of it is in violation and it can't be considered to
My
be law in terms with Article
my lord,
13.
my lord, my other contention is that if they are also entitled under STSC Act, they cannot say that I help to settle in this land only. They
Why
can be
not?
set. No,
All along they have been revising.
possessory.
They are however, they are out there cultivating out there in this very plot of land.
My lord.
Then are you going to just because the father has died? Okay, now you have
No,
no right. We will give you in some other place which is not cultivable.
The act goes
Forget
somewhere
about
else, my
this
lord.
act. This court will very well hold this rule cannot be enforced in view of Article 13. It can't be a law.
My lord.
How can you say that the woman would not get it?
No, I'm not saying that.
No. If we go by this rule, it says so.
My lord.
If the daughter is there, the daughter it can inherit or get anything right over that. It has to be the husband of the daughter.
And perhaps
Really
this
see
is
this.
the
What is the
well,
meaning?
this is the that same
You
plot.
see, and where a daughter is the heiress, the name of her husband should be recorded as a household. If he is suitable for employment, the name of the heirs who are minor will be recorded as forest builder when they become fit for work, or in the case of female, when they marry husbands suitable for employment as a forest. My goodness.
My lord, 1930, we are in 2023. That I admit, my lord.
Then,
That-
and you are relying on
that's
that
not
rule.
No, my lord, they are also claiming that, my lord, because their right started from there only. If they,
A right, if it is started on the basis of a rule which gave a right, that right, it cannot be curtailed on the basis of a rule which is not a law now. Can you say this to be a law under Article 13? No.
it has to be tested. Nobody has tested, my lord.
Tested? What tested it is?
And that, my lord, if I can recall, my lord, this is the plot of land, my lord, recall the Dashrath Jadhav case. Dashrath
No,
Jadhav.
that is a
Yes,
different.
no, my lord.
That
That is
has
also
a-
Rampur Kaki, my lord.
Yeah.
That plot, perhaps that.
No,
plot,
no,
my
but
lord.
whatever
Yes,
may
my
be,
lord,
that
yes.
is another plan.
That
That
is
is
another
another
issue.
thing where they have nothing on it.
My lord,
But here you admit it was given in the name of the father or grandfather.
my lord.
Yeah.
No,
In that
heritable.
case, there
Yes,
was nothing. They only came in 1991.
my lord.
In 1991, they came. In 1993, they asked that it should be given on the basis that there were similar orders being passed by this court, which you said that it is not possible to give it.
Right.
And therefore, this writ petition was filed and came up before me.
My lord. Well, it listed some other demand. I have maybe, and then another issue came up. my
And
lord.
Mr. Over, kindly become reasonable
Yes.
with all these things.
No, no,
Don't
I'm
be so.
reasonable.
No,
This
no,
was
you are
the
not.
reasonance. I was not going
You
to
are
oppose
not.
anything.
You are not. You are asking them to be put somewhere else with an uncultivable forest. They have been cultivating in that area. Ji.
Well, many tests are there. Are they now still there forest dwellers?
You have got
Are
a
they still
stay.
dependent? Malus, there's no stay.
Huh?
No stay.
We grant the stay. List the matter again. Matter upon being heard. Revealed. Matter upon being heard and the instructions produced by the Divisional Forest Officer, Nagaon South Division, Hosai, revealed that the grandfather of the petitioner, one Shiva Shankar Mahili, since deceased,
Few suddenly.
Shankar, Shiva Shankar, S-I-V-A, Mahili, since deceased, was allotted 12 acres of land of Rampur Forest Village bearing dark number 175. However, upon his death in the year 2014, 8 acres of the land bearing dark number 175 have been allotted in favor of the private respondent number 6 to 8. And the remaining 4 acres of land in question is in the process of Ram Apat Chauhan, the respondent number 5. During the course of the hearing, Mr. D. Gogoi, appearing on behalf of the Forest Department, have produced the rules for establishment and control of forest villages. And more particularly, referred to Rule 6 and submitted that there is no heritable right in respect to the land allotted to a forest villager. However, a question arises as to whether the divisional forest officer at all had considered the case of the petitioners before making the allotment in favor of the respondent number, the private respondents number 6 to 8, and further while processing the proposal to settle in favor of the private respondent number 5. This aspect would require a further deliberation, more so as to whether the rule number 6 of the said rules can at all be considered to be law in view of, in terms with Article 13 of the Constitution. As it prima facie appears to be in violation to Article 14, 15, and 16 of the Constitution. This court further is of the opinion that the rights that opinion that the rights of the inter se rights amongst the petitioners and as well as the respondents in respect to the land in question this court is further of the opinion that any further development in the instant proceeding, just for example, that is granting of allotment in respect of the respondent number 5, would lead to further multiplicity of the proceeding. Further to that, if any further rights is divested by the respondent number 6 to 8 in respect to the land allotted to them, would also affect the rights of the petitioner. Under such circumstances, this court directs the Divisional Forest Officer, Nongao South Division, as well as the respondents herein, as well as the private respondents herein, not to affect to maintain status quo as regards the right, title, as well as possession over the land in which.
Well, even after that also, they cannot sublet also. Those parties, the private parties, they also cannot sublet, they cannot also sell. They are subject to, again, if somebody goes, then TFO has to consider again.
The instruction to place on record is kept and marked with the letter X. No, they cannot sublet.
Another
You
issue
should not
comes up.
proceed
Did they,
of
did
giving
they
it
also
to
apply,
respondent number 5.
after coming of the act, the persons who are living in the forest, they have to also apply, It's not automatic. They have to also indicate that whether they had applied for that settlement or not. Permanent rights,
Where is it?
No?
Where is
The
it?
act says, they have to apply.
Where?
They are asking, the very foundation of this case, they say that their rights have been violated, which are guaranteed under the scheduled tribes and other act, this act.
Then
They also have to apply, Did they apply,
apply to what?
apply for this their rights, that they are forest dwellers, and they can be settled with,
Hmm.
If any application was, filed by them, for their own benefit, I'm saying. We can apply for that. Yes, they have never applied. This act doesn't automatically cover, The whole foundation of this case that they are scheduled tribes and other forest, traditional forest dwellers, and they are protected. But that act, one has to apply. There's a mechanism out there.
When was Annexure D submitted?
Annexure.
D.
It has
Because my date is 26, 2015.
Hmm?
It was dated 26, 2015.
26-6.
2015.
এখন কেন এখন 16 একেটা ডেটত এখন 15 এখন 16 কেন একেটা ডেটত one is of 15, one is of 16. This is not legible.
Where?
20, madam, they rely on 20.
No, I'm
27.
saying about Annexure D, page 27.
27.
27 doesn't
It
give
was
any
not
date,
there,
my
but-
lord. No date.
Huh? There's
No,
no
not
date.
Yeah.
No
When
date.
was it received?
No receipt, nothing, my lord.
Huh?
No, my lord, I don't see anything. No, my lord, even in the vernacular, my lord, date is not there.
And the Annexure E, whether it was at all received?
He is a certificate, my.
Hmm?
He is a certificate.
No, Annexure E.
29 my page. Original.
This is also another applicant.
Yes.
Then? And when was it given to the respondents? 6 to 9?
My lord, they have stated in their page 24.
When?
It was
On the next day, Mr. D. Gogoi shall also apprise as to when the private respondent number 6 to 8
Correct.
were allotted the lands
My lord.
as mentioned in the instructions as marked, kept on record and marked with the list. Is the matter when?
2 weeks. Lordship,
Is the matter again on 13th of March? Unlucky.
very well.
outline.
All right.
Timing at in 3.
Yes.
May please, your Lordship. Lordship, I have got the instruction.
Ah.
The petitioner company was closed down way back in 2022, your Lordship.
What?
The petitioner company,
Ah.
it was cancelled. The license of the petitioner company was cancelled.
All everything.
Everything, your Lordship.
Then what remains? Nothing remains in this petition. Luckily, I asked you. Because on that day when Ms. Bormon gave that we are not doing it. Because of that particular as to whether it will fall within that aspect. Now for 45 one year. Luckily, I asked you on that. Otherwise, it would have become.
Instruction, your Lordship, relevant part, paragraph 5, your Lordship.
The record, the instant petition was filed by the petitioner, has been filed by the petitioner, being agreed by the actions of the the actions of the deputy commissioners of the districts of Assam, not to enforce the provisions of the Assam. Now, seeking a direction upon the respondent authorities, more particularly the deputy commissioners of the districts of Assam, not to enforce the provisions of the Assam Protection of Interest of Depositors, bracket, in financial establishment, bracket close, Act 2000, as amended in respect to the petitioner company. The said relief was sought for at that relevant point of time, taking into account that the petitioner had a license to carry on the business or business as a
Non-banking financial institution.
non-banking financial institution
Without accepting public deposit.
without accepting public deposit. Mr. H. Buragwai, the learned counsel appearing on behalf of the Reserve Bank of India, submitted that by an order dated 9/9/2022, the license, the what is COR?
Certificate of registration, your
Huh?
Lordship. Certificate of
The
registration.
certificate of registration bearing number B-08.00177 dated 30/10/2008 issued to the petitioner company was cancelled. And the petitioner company has been advised to stop carrying out financial business with immediate effect. The said order has been placed before this court during the course of the hearing, and the same is kept on record and marked with the letter Z. So, taking into account that the petitioner presently does not have any license, so the question of issuance of a writ as sought for by way of the instant writ petition does not arise. So, accordingly, the instant writ petition therefore stands dismissed.
Thank you.
उसका प्रावधान उधर बैठा हमने जानेगा हमने जानेगा तू नहीं जानता दीवानी वो खाना है बोला है था हाँ